floundering around looking for something to read over the summer, forget it. I got it for you. Here, forget Oprah and her book list. I'm going to give you Popok's book list. Jonah Bromwich, Dragon on Center Street. You heard me right. This is the definitive story of the trial, the indictment, the arraignment, the trial, the conviction of the first United States president or former president, Donald Trump. And Jonah has insider perspective, not just because he's a New York Times writer, but because he was in the courtroom every day, outside the courtroom every day, had an intrepid group of other reporters with him, including a secret weapon, a former prosecutor, now a reporter for the New York Times, that helped guide them through some of that process. Jonah gives us to us straight. And here's a clip from an interview I just did with him about his new book that's out. And we take it from, I pose a question to Jonah as a fervent court watcher and a trial lawyer myself. Did the first conviction that Alvin Bragg, the prosecutor for New York, obtained against the Trump Organization, 17 count of felony conviction for tax evasion and business record fraud, using many of the same witnesses and against many of the same lawyers for Donald Trump, did that embolden Alvin Bragg to finally bring the 34 count felony conviction against Donald Trump himself? What was the impact of the first trial on the second trial? And who's better to answer that than the author, Jonah Bromwich? And here's a clip. Comports with how you wrote about it as legal analysts on our end. We really saw the dress rehearsal for this case being the 17 felony count conviction that Alvin Bragg, in front of Judge Merchan, obtained against Trump Organization entities for tax evasion. It was many of the same players. Oh, yeah. Cohen, Alan Weisselberg, Merchan, the judge, Susan Necklace, the defense lawyer, and Trump goes down in flames. Alvin gets his conviction of the first thing. He made a decision to put that case first, and he does it, right? And did Cohen testify in that case?
I don't think Cohen testified in that case, but certainly Weisselberg.
But Weisselberg did. And Necklace is the defense lawyer by herself. She loses. Right. Bad. 17 count goes down. My working theory at the time is that Alvin, having made two things were going on. He and Letitia James had arranged that Alvin wasn't interested in the fraud case. He would leave that to the persistent fraud powers of the attorney general. And she would go after it in a bench trial in front of Engoron after 2 years of investigation, using some of the same people. And he would go after, but first, he'd go after this 17 count felony conviction. Having gotten that, and Cohen having already reasonably successfully testified in front of Engoron. I mean, there was a lot of debate about whether he perjured himself there, but sure. Engoron said, I believe him now. Right. About these issues. Having seen all of that, do you think that impacted Alvin Bragg's ultimate decision to seek the indictment and to try the case that your book's about?
Yeah, 100%. I agree with your theory. And one of the things that I think is important to know, so Alvin Bragg comes into office in 2022, and he just has some of the most brutal early months of a tenure that I can ever recall having seen. So he puts out something called the Day One Memo. He had put it out on the campaign trail in order to receive endorsements from some of the more kind of left-leaning figures that are relevant in the criminal justice space in Manhattan. He puts that out. The New York Post just goes after him, saying that he's going to let criminals out of jail. And that he still hasn't really managed to elude that criticism from the right. And then the next month, very importantly, he decides not to go forward, as you mentioned, with the valuations case as a criminal case. Mark Pomerantz and Kerry Dunn, the two prosecutors who had been leading that case under his predecessor, resign. The resignation immediately hits the New York Times. And it's just an absolute circus. And Alvin Bragg is a human punching bag for months and months. And I think it was just a really, really low point very early in his tenure. And so without the win, the early win against the Trump Organization later that year, they get the conviction in December of that year. I'm not sure that Alvin Bragg goes forward, given how these cases have gone so far. But that's a real turning point for him. And then importantly, the other similarity between the Trump org case and eventually the case against Trump is that the prosecutors are Hoffinger and Steinglass. And that's where they find their chemistry. Those are two very intelligent, very stubborn people. They often kind of argue with each other. I say in the book that they have an almost sibling-like relationship. I think there's a lot of love there, and there's a lot of combativeness there. I think I was once in an elevator with them, and they always try and, kind of hush up when a reporter's in the elevator. They know who I am, of course. And yet they still couldn't quite keep from ribbing each other.
See, when I see, I didn't mean to interrupt you. Go ahead, finish.
Oh, no, it's just the nature of their relationship is to kind of work closely with each other, fight a lot, and then also have each other's back.
When I see colleagues like that, I often, to break the ice, I often look at them, whether they're, regardless of sex, what their sex is, and I'll often say, "How long have you guys been married?"
Yeah, exactly. That's the vibe.
and that came up, but together they're a powerful force. And the lineup changed, right? The trial could have been, this would have been a different book. Alina Habba and Joe Tacopina defending the case for Donald Trump. He then switches because Habba's not qualified, and Tacopina basically fires himself after not wanting to do that case and the whole E. Jean Carroll thing and all that. Mm-hmm. And so Joe Tacopina bails. Habba's not qualified to do this. They move her over to the $500 million civil fraud case, which is not good either. And then he brings in two at best, federal litigators with very little defense experience. At least Emile Beauvais had very little defense experience. Todd Blanche and Emile Beauvais, who went out and started their own firm with one client. Right. This is another book for you. When you do, the reporter with the dragon books, when you do the next dragon book, it'll be about how all of these lawyers like Chris Keiss and Blanche and Beauvais had to leave their law firms in order to take on one client. And that was very interesting. Right, it was captured law firms handling these cases because no big firm, and now we're seeing the retaliation of Donald Trump against big law as a result, no big firm wanted to touch him with a 10-foot pole. But Blanche and Beauvais, federal litigators who at best were prosecutors, which is a whole different gig, are now in state court, state rules, state procedures, the wild, wild west of state court, not having done a lot of trials, having done zero state trials. And they're up against Hoffinger and Steinglass. Talk about that lineup and how federal white shoe lawyers versus these two roll up your shirt sleeves, Court Street prosecutors. How did that play, and how did that play in front of the jury?
Yeah, this is one of the themes that runs throughout my book and that I personally find really fascinating. Speaking a little more generally, I have detected within federal prosecutors and former federal prosecutors some arrogance when it comes to state court. It is often thought to be lesser than, I say in the book, that it's considered kind of the grubby little brother of federal court. It is dirtier. It is more chaotic. And because federal prosecutors, and particularly federal prosecutors who practice in the Southern District, the hallowed Southern District in Manhattan, often are confident and rightly so in their legal ability and legal skills, they think that it will neatly transfer over to Center Street, and state court will not prove much of an obstacle. And that's often not true. State court has its own procedure. It has its own quirks. And one of the things I think we saw in this trial was just that lack of knowledge about how things work on Center Street really hurt the defense case here. The defense, I think the thing that you have to say about their case, both here and in their federal defenses of Donald Trump, is that outside the courtroom, they were often very effective. They delayed cases in the way they wanted to. The federal cases obviously fell by the wayside after Trump won the election. But once in the courtroom, at least in this case, I found that Todd and Emil just did not answer to the case the prosecutors were presenting in an effective way. And furthermore, I really believe that this was a case that could have been defended. I think that they could have won this case. And everyone says, a Manhattan jury would always have convicted Donald Trump. And they may be right, but they also may be wrong. I think that this was a winnable case for the defense if they had played it very, very differently. Very
interesting. They should. How about if Susan Neckles, who got put on the back bench? You say because she refused to use a letter or to co-sign a letter that was written in one of Donald Trump's fevered moments to attack something or someone, including, as we know, I want to get to Judge Merchan in a moment. Judge Merchan, his daughter, and everybody around him. But I thought that Trump had lost tremendous confidence in Neckles because she had gone down in flames 17-0 in the prior case. What's your reporting on that?
Yeah, so what I've reported and what I believe to be true is, of course, that before the trial, Blanche and Beau were acting extremely aggressively in terms of the motions they were filing, asking Mershon to recuse himself, not once, but multiple times, appealing things up to the First Department, which is the mid-level appeals court in New York, 3 days in a row right before the trial. And then they wrote this very, very aggressive letter attacking Alvin Bragg in a way that was kind of a preview for some of the things they would say after the trial. And on that letter, Susan Nicholas didn't sign it. It was notable that she didn't sign it. And Nicholas, who was supposed to do really significant cross-examinations, including, I believe, the cross-examination of David Pecker, probably the most important witness in this case, other than Michael Cohen, often kind of forgotten just because he's not quite as public as Cohen or Daniels. That cross-examination, instead of going to Nicholas, went to Emil Bove, who's a very competent lawyer. His reputation has really kind of taken a dive, given all that he's done since coming into the Department of Justice.
You mean Judge Nominee Bove?
Oh, Judge Nominee Bove. That's right. For the Third District, but
for the Third Circuit, yeah,
the Third Circuit. Excuse me.
Yeah.
But he did the cross-examination of David Pecker, and he had never done a cross-examination before. So imagine this: you have the first American president ever to go on trial. You have the first witness, and an incredibly key witness, who is going to testify not just about 2 of the 3 hush money payments that matter, but also about the conspiracy between himself and Trump and Michael Cohen. And rather than having like a really experienced state practitioner cross-examining the guy, you have someone who, as competent as he is as a lawyer, has never done a cross-examination before.
He never did it as a defense lawyer. He never did it even as a prosecutor.
He had never done it as a defense lawyer.
Well, that still matters. That's still an important difference. Let's turn to when your cast of characters, one of the ones that caught the imagination of the public, which is Judge Mershon. Our reporting and people that knew him is that he was, despite how he was portrayed by Donald Trump, he's a very temperate, even-keeled, deliberate, just what you want in a judge. Not over. Look, I've had a lot of emotional judges in my career. Not that, but you also portrayed him. And look, we all know from your writing and your reporting at the time how mercilessly Donald Trump attacked him. Not him directly, even though sometimes out in the press conferences he would. But there was like this weird respect. Donald Trump's got a thing for guys that are good looking, and he doesn't seem to go after them. You know, there's a couple of women he won't go after either, like Nancy Pelosi and Claudia Sheinbaum of Mexico, that he sees as his equal. But he has this weird thing, like if it's a good looking guy, he just won't attack him. And
with Mershon in particular, he often would comment, the handsome judge or the very good looking.
Right, it was so weird, but he would go after the daughter who worked as who was a president or vice president of a political consulting and lobbyist firm out in Chicago. And who cares? Unless you can show me a direct link where she's paying daddy every week out of the proceeds of what she earns representing Democratic operatives. We're in 2025. Women are allowed to work. Daughters are allowed to work. And that's not grounds to have anybody recuse themselves or be disqualified. But what I picked up from you is something I hadn't picked up before, especially like when you were talking about the Stormy Daniels testimony and the Bob Costello testimony. You reported that there were moments where he went from this thoughtful finger to the mouth where he was thinking to disgust, anger, red-facedness, to the point where he clears the courtroom during Costello. You can talk about that and where you think that was actually a retaliation against the press. Why don't you talk about what you observed with Judge Mershon as a foil for Donald Trump and how he did overall in administering justice in that courtroom?
Yeah, it's such an interesting question. So I have a line earlier in the book that says Donald Trump exerted a force that it compelled others to contort themselves in response to him. And I think the institutional players, the institutional avatars in my book, both Alvin Bragg and Juan Mershon are great examples of that. So Juan Mershon, as you said, a real standout judge in state court. As you said, and I think as I say in the book, that state court is just like the Wild West. It's often a really crazy place. And you and I'm sure, have both seen no shortage of judges absolutely losing it all the time. I mean, there are judges in there who just kind of yell or they'll chew out a lawyer for really no reason at all. And so the courtroom can be like a really wild and crazy place to be. And that is just not true in Mershon's courtroom ever. He's very steady. He's very calm. He presides over mental health court. So he often sees, I think, defendants who can fly off the handle, who have difficult time being in that kind of sober atmosphere. And he does that very calmly and actually does a great job keeping things steady and moving ahead. So he was, I think, many people in the system at least thought, the right choice to preside over this trial. And for the most part, he really kept his cool. He and Trump, as you say, had a very not quite positive relation in the courtroom, but totally respectful on both sides. Trump stood up when Rashawn would come in. They shout, "All rise," and Trump obeyed that order from the court officers. And he would say, "Your Honor." So totally respectful.
Well, on that, before you move on from your book, there's a moment where Rashawn, in trying to evaluate whether contempt was appropriate and how to hold Donald Trump responsible for what he was doing outside the courtroom, inside the courtroom, he says, "I don't want to put you in prison, but I will if I have to." That's the implication. And there's an impact on Trump. Use that as to talk about that relationship.
Sure. Yeah, 100%. Because you hear this a lot, that Trump is very different in private than he is in public. And it's 100% true. And so his relationship with Mershon is a great example of that. He was slamming the judge as corrupt and biased. He was going after his daughter. His daughter runs marketing campaigns for Democrats, including Kamala Harris. But it was, as you say, really hard to draw a connection between them. And one of the things the defense lawyers kept pressing was that the daughter had commented in a podcast interview, I think in 2019, that her father had once told her that he didn't like when politicians writ large tweeted. So that's an example of kind of a little bit of grasping, right? Like they didn't have anything that could link what the daughter did with who Mershon was, I thought. So outside the courtroom, Donald Trump is going after the daughter. He's going after the ex-wife briefly. He's going after Mershon himself. And then inside the courtroom, totally respectful, and I think a little intimidated. And one of the things we saw in particular is that Mershon imposes a gag order on Trump right before the trial begins. Very narrow. Don't attack my family. Don't attack the prosecutors or their families, although you can attack Alvin Bragg. That's fair game. And don't attack the witnesses. And Donald Trump immediately begins to violate that gag order. And at 11 times overall is what the prosecutors eventually accused him of doing. And he does it and does it and does it until the day that you mentioned in court, where Mershon warns that he will put him in jail if he continues to do it, that he doesn't want to, but that he will. And people often think, I think, of Donald Trump as this like impervious and fearless. Absolutely not. I mean, this guy was not. He was scared to go to jail. He was very scared to go to jail.
So that shook him. That rocked him to his core. That shook
instantaneously. The behavior changes. He doesn't continue to violate the gag order. He clearly knows where the line is. And does not cross it. And furthermore, that's when he starts bringing Republican allies to the courtroom to violate the gag order on his behalf, so to speak. These are people who do not have a gag order on them and who can insult the witnesses and who can insult Mershon's family. So he gets around it through the use of surrogates.
I want to talk about Michael Cohen, who, of course, is on our network. I know Michael well. Bob Costello and Stormy to round out our interview here. There's a moment in the book, I want to see what you think. There's a moment in the book while Michael Cohen is on the stand. Disrupting his testimony is this group of Republican operatives and surrogates who march into the courtroom at that moment. Was that a timing thing? Did they know from reporting that, how did that happen? And why did that happen at that point?
This is a remarkable moment in the courtroom. Yeah, Michael Cohen's story, as your listeners likely know, is a story of breaking from Trump and breaking from Trump in a really dramatic fashion. And the way the prosecutors had prepped him, he was going to tell this story as an emotional story, as a patriotic story about putting his family and his country over his loyalty to Donald Trump. And it worked. He's a good performer. And so it was a very dramatic moment as he was leading into it. Susan Hoffinger is questioning him. And then the double doors of the courtroom burst open and Vivek Ramaswamy and Burgum, I believe, and these other Republican politicians come in right at this most emotional moment.
The vice presidential candidate tryouts.
Yeah, exactly. And I don't think it was timed precisely. That just would have been so hard to do. But Trump's entourage, which is the biggest entourage I've ever seen for a defendant in state court at this point, grows enormously during the week that Michael Cohen is testifying. And it was very clear, and I think we reported at the time, that this was just a direct attempt to intimidate Michael Cohen, who everyone thought the question was, will he break or will he testify credibly? And so we saw a real show of force on Donald Trump's end to try and, I think, throw him off his game.
When you're, I'll talk about it from a trial lawyer, then I'll turn it back to you as the reporter and the author. From a trial perspective, you always want to try to create an internal momentum for your trial in how you sequence your witnesses. You have to make adjustments. If a witness craps the bed, that's a legal term, that you weren't expecting. Or sometimes you get a witness that you thought, it's going to be a white knuckler for me, but I have to put the person on to make a point, and they do like amazing.
Right.
And other ones you're like, oh, this is going to be perfect. They're going to love this person. And you can tell the jury hates this person, and it's not going our way. So you have to make adjustments. But they made a conscious decision to open with Pecker from the National Enquirer as the roadmap witness, talk about the Trump Tower conspiracy, save Michael Cohen until a lot of evidence came out, including through Trump employees, willingly or not, the timing of when to put on Hope Hicks, who cried famously on the stand, and we'll talk about that, and then bring in Cohen, and then people to follow Cohen. Of course, the trial didn't end right on Cohen. And then they had to sit through Costello and be prepared for it, which I thought was a weird person to be testifying, but I get why. Talk about how the power of the sequence that the prosecution used, and if you found it effective, and particularly, did they really need Stormy? Or was that a push at the end in terms of she was good? I mean, people were riveted at parts of her testimony. It almost sent the judge into apoplexy during most of it. It was such a roller coaster of emotion for him. But did they really need that? And then just talk about how the power of the sequence of their presentation of the case to that jury.
So just to remind people about this case very briefly, there's two elements kind of merged together. There's falsifying business records, which refers to the reimbursements to Michael Cohen being said to be about legal matters rather than returns for a hush money payment. So that's like kind of the paperwork part of the case. And then before that, there's this 2015-2016 election conspiracy that involves this sequence of hush money payments, that conspiracy. And what the prosecutors did in their sequencing, I thought extremely cleverly and extremely effectively, is that they knew the conspiracy was the fun part. It was the interesting part. There was political intrigue. There was sex. There was media. There was celebrity. And they put all that stuff in the front. David Pecker started it out. David Pecker, the former head of the AMI, which runs the National Enquirer and other tabloids, explained this conspiracy, really gave the jurors a new view, I think, of the 2015-2016 election, and brought in all these kind of celebrity names, Trump himself operating from The Apprentice in a way that kept the jury completely spellbound. I've never seen a jury like this where they were just completely locked in from the word go. And so once that was in place, then the prosecutors very quickly and somewhat tediously brought in the paperwork case, and that all went by. And then by the time they had Michael Cohen on, as you say, so much had gone in, and the jurors were likely so convinced that the conspiracy part of the case had happened that they may not have been quite as attuned to. And I don't think Donald Trump's lawyers, as I say in the book, were quite as attuned to the importance of Cohen's testimony, because to prove the prosecution case, they actually did have to prove the falsifying business records case. And that rested almost entirely on Michael Cohen's credibility about two conversations, one of which included Alan Weisselberg, who was never going to testify, and one of which was just him and Trump. And one of the big mistakes I think that the defense may have made is not showing the jury very specifically, these are the two conversations that matter. These two ignore everything else.
Right. If you have reasonable doubt about these two conversations, you cannot convict our client. And right. Michael Cohen, blah, blah, blah. Yeah, you're right. No, you could tell they lost the forest for the trees. And I don't know why they were so flat-footed about how the case would be presented. I mean, there's no prosecutor or a defense lawyer that would have led with Michael Cohen. Right. Right. Michael Cohen is the thing in the distance you get to after you do a lot of insulating before, right? That's what they were doing. They were socializing Michael Cohen with the jury weeks before Michael Cohen arrived.
That's right. And I'm curious how you think of this as a trial lawyer, because I can see why, if you want to discredit a very key witness, why you might start that effort early. But at the same time, it reminds me of the, they doth protest too much type of thing, where they've spent so long attacking his credibility that as a juror, rather than focus on whether or not he is credible, I might start to focus on him simply as important and say, this is the guy that the defense really hates, rather than saying, this is the guy who I have to watch out for.
Yeah, what I think happened is, as always, as you said, Trump has an ability, I'm not paraphrasing you, to warp people around him and their thinking. And I think that if he had really independent lawyers who were doing right by their professional responsibilities and were more seasoned trial lawyers, they would have done a little Heisman move to Trump a couple of times and said, listen, I know you want to go after Cohen and you think Cohen is the most important thing. If we prove he's a perjurer, this case is over and that's reasonable doubt. We don't see it that way. We know what their case is going to be. And while important, we can't put all our eggs in that basket. But I think because they were inexperienced trial lawyers and because of the relationship Donald Trump has where he doesn't really respect his lawyers, let's be honest, and won't listen to them at the end of the day, Donald Trump became his own strategist and his own quarterback.
Well, there's some evidence to substantiate that. So as we've said, and as has been said ad infinitum, this case does bring kind of an unusual legal theory, a novel legal theory. And I think it is absolutely right that people scrutinize that. 2 judges blessed it on the way to the trial, including Alvin Hellerstein, a federal judge. So it's not as if judges just ignored that the legal theory was unusual or never been built this way. But it is appropriate, I think, to take a close look at this legal theory. That being said, once you're at trial, that's the time for kind of worrying about the legal theory is somewhat over, and you have to focus on the jury case. And Todd Blanche, in his own interviews, has always said that he really thought this case was bullshit. And I take him at his word on that. I think he did. But I also saw the way that thinking there was no crime here and trying to convince the jury that this wasn't even a criminal case, really. I didn't think that was a lane that really worked for them. I thought it was a difficult road to hoe. And
to your point, and in your book, it infected all of their interactions with the court and with the jury. Like when he said, you reported in your book, like when he said to Judge Merchan, we don't even think we have to be here. Right. He said, stop, wait, I'm sorry, I have a jury in the hallway. What do you mean you don't think you need to be here?
Right.
You know, well,
we don't think this should be a criminal case. I mean, he's saying that.
We're beyond that point at the moment when the jury is getting a Grecian urn cup of coffee outside. I mean, that right? We're beyond that. We're now up to, you can take that up with the appellate court, right? But we got a jury at this moment.
Yeah, kind of amazing.
Let's just end with I didn't pick it up as much in the day-to-day reporting about Bob Costello and what happened there and the judge and the clearing of the courtroom. I knew it had happened. I interpreted it a different way, but you have a very reasonable, having been in the room, a very reasonable position about why the judge cleared the courtroom at that particular moment. So Costello works with Trump, right? Michael, because that Trump tells him to, and Giuliani tells him to, is considering hiring Bob Costello for his own criminal problems, because we all know Michael famously went to jail for many of the things that Donald Trump did, and then Michael Cohen did as well. I mean, let's be frank. But the Costello is then because of Trump, is on a vendetta tour of his own. He goes to Congress with Elise Stefanik to testify about lawfare and about Michael Cohen, calls Michael, who used to be a client for a moment, calls Michael Cohen a liar. And he told me at one time he doesn't have any goods on Donald Trump. And now, of course, he says he does. So they bring, and to Alvin Bragg's credit, he lets Costello be the sole defense witness to address the grand jury. And that doesn't work because they get the indictment, but then they bring him into the courtroom. But there were motions in limine and motions to limit the testimony of Bob Costello. But you point out nobody seemed to get that memo over to Bob Costello. And let me just give it let me do a little nerd out on the legal side.
Sure.
If Bob Costello was already on the stand and under oath, and a judge had made a ruling about the nature of his testimony, there's a good argument, unless you get judge permission, that you can't tell the witness currently under oath about the limits to his testimony. I've been in cases where actually talking to the witness may be a mistrial, about a ruling that the judge made while they're on the stand. But the rulings about the limits to Costello's testimony were made before he was sworn in. So what happened there? Why is Costello doesn't understand it, is now frustrated and acting out in front of the judge with eye rolling and sideways glances about his testimony because he can't figure out why he's not being allowed to tell his story? What happened there?
The Costello story is just absolutely incredible. So as you say, he and Michael Cohen are consulting in 2018 when Michael Cohen is in deep legal trouble. He hasn't yet broken with Trump. And Cohen begins to suspect that Costello is telling everything to Giuliani, who was his close confederate, who was, and at that time, President Trump's lawyer, who was then telling them to Trump. So there is a brief moment of interaction between the men when Cohen is considering hiring him as his lawyer. And then there is a massive kind of break and fraying of trust. And it's like something out of a Greek tragedy. The two men can't stand, and particularly Costello cannot stand Cohen. And I say in the book, he's like a vengeful ghost following Cohen around wherever he goes to tell anyone who will listen that Cohen is a liar and can't be trusted. So he does that in the trial. And the prosecution understands that Costello is going to be this way. And so they ask for limits on his testimony. This is not a trial of Michael Cohen. It's a trial of Donald Trump. Merchan hears them out, hears the defense out, places some careful limits around Costello's testimony because he agrees that he doesn't want it to be a trial within a trial of Michael Cohen. No one tells Bob Costello. No one. Like we know for a fact, no one tells Bob Costello. So this is a guy who goes in, sitting in the witness stand, and he's trying to just testify, but everything is getting objected to. Susan Hoffinger, who's doing the cross-examination of him, is objecting, and she's objecting successfully. And Costello, who has a lot of self-confidence and doesn't like to be interrupted, let's say, is just getting more and more frustrated because he doesn't understand, and he starts kind of, giving the side eye to the judge. And then at one point he says into the microphone, geez, after
right.
one objection is sustained. Yeah. And then he says, strike that, to try and strike his own testimony from the record. And Merchan is getting more and more upset. And this is the end of the trial. So Merchan's nerves, I think, are already pretty frayed at this point. It's been a very difficult 7 weeks or 6 weeks at that point. And then he's starting to lecture Costello. He's asked the jury to leave the room. He asked Costello to kind of behave himself, and the conversation seems to go okay. Except at the end of it, Merchan sees Costello just staring at him, and he says, "Are you trying to stare me down right now?" And then Merchan, and my theory is that he didn't want to freak out on Costello as the sole substantive defense witness. And seem biased in that way. He didn't want to freak out on the prosecution. That wouldn't have made any sense. So he ejects the media from the room. He's never been all that, he doesn't like reporting that much. He doesn't like reporters that much. He was frustrated with us during jury selection as well. His obligation, as he sees it, is a great kind of classic institutionalist, is to the jury and the smooth running of proceedings. He ejects the media.
He got frustrated with the press because of the woman who said she was outed because of her job and she had to leave the jury.
He didn't like the way we were reporting about prospective jurors. We were trying to kind of fill in the public about who these people were. There was a guy, the four-person ended up having a guy, Irish immigrant, a guy with an Irish accent. I mentioned that reporting. He called that out specifically.
Because they were anonymous.
They were anonymous, and he didn't want them to be in danger. And he was right to be protective of them, I think, and perhaps a little more zealous than I would have been in just how far he went to do so. But this woman, an oncology nurse, was identified, not by anything we did in the New York Times, but some people, I think, went further and were naming people's workplaces, for instance. And in fact, Kate Christobeck, all credit to her, because very early in the trial, she's the former prosecutor we were talking about earlier, said to our team, we really got to be careful with these people's workplaces. That is what's going to dox them. And so we never named anyone's workplace.
Yeah, for me, and you were in the room, so I trust your reporting. For me, listening to what happened, I thought it was that, as you said, Merchan had lost it. He could have taken lawyers in chambers now, and maybe even grabbed Costello at that moment.
Mm-hmm.
And you would not have been in that room. There would have been a transcript at some point that you would have gotten a handle on. But yes, he made I think he just lost it. He just got a very public showing.
100%. And you can tell he did because it's in the transcript and he makes sure it's public. And I've seen this with Merchan a couple of times. Again, I have a lot of respect for him. He was in a very, very difficult situation. But you would see places in which he would seem to kind of lose control and then immediately rein himself back in. And so this is kind of the most explosive moment of him seeming to lose control. And then you see it in the transcript. Obviously, I wasn't in the room for this, but he says, the press were very upset because we all start standing up and shouting when he tried to
including you.
Yeah, that was the first time I had objected in court. And he says, the press were very upset, and so I'm going to make a clear record. But he never said either then or later kind of why exactly it was the press that had been kicked out. And I just thought it was a very telling moment. Yeah,
I think he lost control and it was theatrics, and I think he wanted to reinforce to the witness how serious this thing was, that it just happened. And the press was an easy foil, right, for that to happen. Let's end with Stormy Daniels, right? People are probably like, why didn't you lead with Stormy Daniels? Why are you ending with Stormy? So talk about your view as an observer of the importance of bringing her in. There's a little bit of a white knuckle moment for the prosecution, right? She misses a plane at one point, which throws off the prosecution, right? Put the cadence of putting on witnesses. And then there's another renewed discussion that you report on in your book about, do we need her? Do we have to put her on at all? And then there's the judge who, doesn't want to hear about missionary style and sex acts. But why do you think it was important? And was it important for the jury, in order for the cover-up part to be adequately presented, that you hear about the act? I mean, we know Donald Trump had denied that he had sex with her. We know that Donald Trump had denied, other than it's always whatever the photos show. It's just me with her, like on the golf course. Yeah, okay. Right. So people have to come in and say, no, there was more to that. There was a dinner. There was a meet. She's on the Rolodex with another woman at Trump Tower. She's got access. So, do you think it was important? And how do you think her testimony with Mershon, right? Susan Necklace, who puts her on? Hoffinger.
Hoffinger, yeah.
So it's the battle of the Susans, as you refer to it.
That's right. Yeah.
All right. Talk about that. Well, that's a good way to end our interview.
You're right. It's an incredibly contentious thing within the prosecutor's office, and I have a lot of new reporting in the book about some of the tenor of these arguments and kind of why it was so risky. And so the obvious argument against it is that it's too salacious. It kind of makes the trial look dignified, and as if they're just trying to make Trump look bad. And Stormy Daniels knows nothing about falsifying business records, and really she doesn't know all that much about the election conspiracy either. So why put her in? And then folks, including Josh Steinglass, I think, argued that without her there, because she was the origin point for the story they were telling, not the criminal case, but the story, it would be a massive hole in their case. And furthermore, they believed that if she told her story even close to the way they had hoped she would, the jury would feel disgust. They wouldn't be like titillated and excited. They would feel disgust, because when you hear it in person, it's kind of a disgusting story. And that disgust would then be helpful, because they could use it in a closing. They could say, how you felt when you were listening to Stormy Daniels? Well, that's how America would have felt. This is how people would have reacted had she told her story during the 2016 election. So it wasn't that they thought necessarily that the testimony would be exciting or even kind of salacious, in the way that when people say salacious, they do mean people will be titillated by it. They thought it would be gross. And that argument won out. Stormy Daniels' testimony itself was really, really fascinating, because I thought on direct, and a lot of reporters agreed with me, we're all talking to each other after, she was really rough. She was really nervous. She gave out this kind of anxious energy. Stormy Daniels is a fascinating woman, because she's an intelligent person and she's a prideful person. And because she's been a porn star for so long, she feels, I've seen this, because I did a ton of research into kind of how she presents herself in public. She is often kind of justifying and explaining what she does so as to lend dignity to it, so as to suggest, I'm not this idiot you may think I am. I am a smart. And so I thought that really led her astray with the jury at first, where she was defending herself. She seemed defensive. She seemed incredibly anxious. And so on direct, I was like, oh God, terrible choice. They didn't need her. They shouldn't have brought her in. And then on cross, she started to get the hang of it. And the cross was more theatrical. Susan Nicholas, who's a great trial lawyer, was trying to get the better of her. But that's where Stormy Daniels, who's a performer herself, obviously shined. She knew how to kind of come back and counterattack kind of these cutting insults almost.
You're right. She was very good at counterpunching.
Unbelievable.
And Necklace led with her chin. Yeah.
Right. She learned on the stand. This was the only witness who I saw in real time go from pretty rough witness to someone who was a pretty good witness. And I thought she brought her performing ability into the courtroom and learned, when can I counterattack and be successful? When can I be more emotional and be successful? And so she ended up, I thought, being a pretty good witness for that.
My favorite cross that you report on in the book question is when, I'm paraphrasing, is when Susan Nicholas says, well, because in the direct, they called her an adult entertainment person.
Right.
Susan Nicholas is like, you're a porn star, right? Okay. So your job is to have effectively fake sex over and over again in movies, right? And she said, no, the sex is real in the movies, just like it was with your client on blank date for that 10 minutes. I mean, that was a great counterpunch to her. You also had reporting, though, Lord knows where you got it from, about her choice of wardrobe on day one. I think it was day one, right? What was it, and how'd you get that scoop?
She had done some independent movie, and where Donald Trump, I think, was the devil, or that Donald Trump had made a deal with the devil to win the 2016 election, and she wore the same outfit that she wore in that movie to her first day of trial. And then with the reporting, as much as I like to demystify some stuff and other stuff, but I think that Vanessa Friedman, our fashion correspondent, may also have reported that as well.
Those are the kind of things I like. Look at the level of detail that Jonah's going into here on the pantsuit. There's a thing with Donald Trump in clothing, and presidential presidents in clothing. You got blue dresses and black dress coats and black pantsuits. It's all crazy. But on balance, we know what happened. We got a conviction. What does it mean? Look, listen, I have a lot of New York friends and in high places in law. We got together and talked about the case at the time. And I said to them, some were prosecutor types, some were defense lawyer types. I said, what do you think? They said, it for his base, it will make him more electable. That case was so, while it was obviously proven beyond a reasonable doubt to a jury of 12, right? We're in state court. It helped get him elected. I mean, there is a working theory in New York that particular conviction, especially since all the other ones that mattered, like the election interference case and the Mar-a-Lago case and the Georgia RICO case, since they all disappeared. Even though, Alvin gets credit with being the first to indict, the first to try, and the first to convict. That might have been, unfortunately, one of the things that helped get Donald Trump elected.
Yeah, I've seen that said, and I think even in some corners it's become conventional wisdom. I've never seen that reflected in polling. What I think is definitely true is that it made him more electable with his base. Especially, we saw that I think I have this polling in the book, and I don't want to misstate it, but there were a portion of Republicans who were more likely to vote for Donald Trump after this election, after this conviction, and there were a lot of people who didn't care. And the Democrats, I think, for so many Democrats, criminality is kind of baked into what they think about Donald Trump. They didn't care. Independents were not happy about this conviction, and so insofar as the independent vote is what matters, I think there may have been some. But what I think happened is that right after this conviction, you have two really important events. You have the presidential immunity decision, which effectively ends the federal prosecutions against him. And then you have the assassination attempt. Right. And one of the things that Trump has real genius for is telling a consistent and relatively simple, almost archetypal story. And so combine not just this prosecution, but all the other prosecutions against him with the assassination attempt as he did. And what you see is a pattern of victimization and a president who, or a presidential candidate with the ferocity and bravery to rise above it. And that's why I talk about the kind of fight moment. So I think insofar as this conviction may have helped him get elected, which is not clear to me, I think that it's in part both because it was paired with 3 other indictments and because it was so closely followed by the assassination attempt.
Agreed. Welcome back. we bring on guests in addition to the original reporting and commentary we do here on Legal AF. And one of them, we're bringing on a series of authors over the summer to sort of fill out our diet, our steady diet of law and politics analysis. And I loved having that conversation with Jonah Bromwich. He's got the key to the channel. He can come back anytime he wants because he's smart, he's insightful, he writes passionately. It was an easy read for me, and I knew every detail about that trial, and yet I found it to be a page turner of the first order. I read it on 2 flights from Miami back to New York, done. And not just because he was going to be a guest on my show. You're here on Legal AF. If you like this kind of content, there's one way to vote for it. Hit the subscribe button, hit the content section, leave us a comment, come over and listen to Legal AF, the podcast on the Midas Touch Network. And of course, Legal AF, the Substack, where we have all this great material for you, all in one place at the intersection of law and politics. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.